this fall 2025's Visas After Graduation presentation. I'm Hersh Sisodia, Senior Immigration Advisor in Office of Global Learning's International Services side, and I'm joined by our presenter, Crystal Osmond, a partner with the law firm of Miller Mayer. She has extensive experience in the field of immigration law. So what will happen is the format is going to be she's going to do the main presentation, and after that we will take any questions, time allowing. I know there'll be lots of questions. We'll try to get to as many as possible. And with that, I will turn it over to Crystal.
Okay. Thank you, Hersh. And thank you everyone for being here today. As Hersh said, I'm a partner at Miller Mayer. We are a law firm that specializes in immigration. We are located in Ithaca. We are right on the Commons. If you have ever been to Viva, like Margaret, we are right above there. So we are in the neighborhood. And I am going to sort of give you a brief overview of U.S. immigration today. Then we are going to talk about non-immigrant or temporary visa options that might be available to you after graduation. So those are things like H-1B, O-1, TN, etc. And then I am going to go into some of the long-term or permanent residence options. I will sort of start by apologizing and saying that I feel somewhat under the weather. So I apologize if I seem a little slow and or if I'm drinking a lot of water. I did sort of shorten this presentation a little bit from years prior also because I do expect there to be a lot of questions and also sort of trying to save my voice a bit. So with that, I'm going to jump right in. I won't give you too much background or waste too much time on us, but again, we do specialize in immigration and we are close by if you need us. So just generally in terms of U.S. immigration, as immigration lawyers, we sort of break people down into three buckets, if you will. So again, we normally think about non-immigrants or people who are here temporarily. And individuals are generally tied to something. So like a lot of you might be in F1, J1 status, and you're tied to your school. And then in the same vein, typically once you go on and you attain a status like H-1B or O-1 or TN, you're tied to an entity or an employer who sponsors you. In contrast, once you become a permanent resident or a green card holder, you're not tied to an entity. You can work for anyone in the United States, and you can live anywhere in the United States. And then the sort of flip side to that is being a U.S. citizen. And I guess I should say that when you are a permanent resident, you do have sort of an additional requirement, which is that you are in fact supposed to make the United States your permanent and primary residence. So meaning you don't generally want to go and move abroad for a long period of time when you're a permanent resident. But in contrast to that, when you become a U.S. citizen, the U.S. government doesn't necessarily care if you move abroad for 5 years or 10 years. So those are the sort of buckets that we generally think about when we think about U.S. immigration. In the same vein, I'm not going to spend too much time on this, but these are just sort of the traditional immigration pathways that you guys might be thinking of in moving forward. And I would say the most common one, of course, is if you're here as an F1 student or a J1, you might think then, oh, then I'll get sponsored by an employer and I'll get H-1B status, and then I'll get green card sponsorship, and then I'll go on to become a U.S. citizen. And that is the traditional pathway, but you are not necessarily bound to take that pathway. So for example, for some of you, it might be possible for you to go straight from being an F1 or a J1 to being a green card holder. You might be able to skip the interim step. So don't feel that this is the pathway that you have to follow. It's just sort of the normal one that a lot of people do in fact follow. So with that, I'm going to sort of jump right into the non-immigrant options. And there are, in fact, an alphabet of non-immigrant options that are available to individuals. With that being said, there are not that many that apply here. And the reason for that is you can sort of see from the names, a lot of these are very, very niche or very, very specialized. So for example, A classification is for diplomats. D is for crewmen. But what we're going to focus on are the ones that might be applicable to you. So of course, we're going to spend some time talking about the H-1B classification. We're also going to spend a bit of time talking about E, L1, O1, and TN. So I'm going to jump right into H-1B. And I know a lot of you have seen this in the news lately, and I will talk about some of the developments. But I will give you sort of just the basics about H-1B classification to start. So what is H-1B classification? H-1B classification for individuals who work in something called a specialty occupation. So you might say, what is a specialty occupation? So a specialty occupation is one that requires at least a bachelor's degree or higher in a specific field. So what does that mean exactly? It means that there's generally a pretty tight correlation between the degree that you possess and the position that you're going to enter into with an employer. So a good example of H-1B, a good H-1B job would be, let's say you're someone who gets a degree in industrial engineering, and you're going on to pursue a position as an industrial engineer. That's a tight correlation between the degree and the position that you're going to assume. The other thing, I guess I will give you a flip side example to that. Let's say you get a degree in math and you're going on to pursue a job as a fashion designer. That's not going to work for H-1B classification. The other thing to keep in mind is that when you take an H-1B job, employers are required to pay specific wage, which is generally the higher of what we call the prevailing or the actual wage in a specific occupation. And so essentially that boils down to maybe like the average wage that's paid for a particular job in a particular area. So let's say you took a job here as an industrial engineer, the wage that an employer is probably required to pay you is probably less than, let's say, if you take a job in New York City. So it differs depending on your geographical location. Let's take a look. So there are a lot of advantages to H-1B, despite everything that's been going on recently. Of course, there is an advantage in that you get up to 6 years in H-1B status. That 6 years essentially refreshes if you spend at least 1 year outside of the United States. And you do get additional H-1B extensions beyond that 6 years if an employer starts the green card process for you before the end of your 5th year in H-1B status, or you have what's called an I-140 or an I-526 petition approved. So H-1B does give you time to work towards a green card. That's definitely one of the advantages. There's also, I think, contrary to popular belief, there's no test of the labor market associated with H-1B classification. So a lot of people think, oh, an employer has to show that there aren't any US workers before they can sponsor me for H-1B status. But that's part of the permanent residence process. That's not part of the H-1B process. Mm. Another advantage of the H-1B classification is that there's no real delay if you want to change H-1B employers. So if you're working for employee A and employer B agrees to sponsor you for H-1B status, and employer B submits an H-1B petition for you, you can actually start working for employer B as soon as that petition is submitted. You don't necessarily have to wait until that petition is approved. Now, there is some spousal work authorization. So if you're in H-1B status and you have a spouse who's dependent, they would be in H-4 classification. And H-4s can get a work permit, but it's under very, very limited circumstances. And I won't necessarily go into that, but if anyone has a question, we can certainly talk about that. So what are the disadvantages of H-1B status? So sort of what we just talked about, any employer who wants to sponsor you does have to file a separate H-1B petition for you. So it isn't just that employer A files a petition and that takes you forward in perpetuity. Each employer has to have an H-1B petition on file for you. Obviously, there is a lot of paperwork that's associated with H-1B status. There are a lot of costs that are associated with it. And in particular, for you guys to keep in mind, employers are, for the most part, required to bear those costs. So that's sometimes why you see some hesitancy on the part of maybe small employers in particular, in order to sponsor you. And then there has historically been very limited self-employment in the H-1B category. And the reason for that is that in the H-1B context, there has to be an employer relationship between an H-1B beneficiary and the company that's sponsoring them for H-1B status. So it was always very difficult to show, and perhaps still is, that you have a true employer-employee relationship if you're a majority owner of a company. But there was a change in the law recently, so that even if individuals who own more than 50% of a company, they can still potentially secure H-1B classification, though that initial period of H-1B status, which is normally 3 years, so normally H-1B status is granted in 3-year increments. Now, if you are an entrepreneur and you go down this route, you could potentially get H-1B classification, but your initial grant would likely be limited to 18 months, as opposed to the normal 3 years. But nevertheless, that's a really good development. But of course, the primary disadvantage to H-1B classification, excuse me, is inadequate supply. And so what do I mean by that? There are a certain number of H-1Bs that are available each year, and those H-1B numbers are generally for private employers. And so those H-1B numbers are generally granted by lottery each year. So let me go on to the next slide here. So what exactly is the H-1B cap? So each year, H-1B numbers are limited as follows. There's generally 65,000 that are available to individuals with a bachelor's degree. And then there's an additional 20,000 that are available to individuals who have US master's degrees or higher. So it's important to keep that in mind. Some people get confused, but if you have a master's degree from a foreign institution, you don't fall within that master's degree exception. Now, there are some exemptions from the cap. So this cap, this quota, if you will, on the number of H-1B, the number of H-1Bs that are available each year, again, generally applies to private employers. There are some employers that are deemed cap exempt, meaning they can they have access to an unlimited number of H-1Bs. And the primary example of that is probably colleges and universities. So post-graduation, if Cornell offered you a job, they are not necessarily subject to this H-1B cap. Another common example that we see a lot is particularly in the physician context, there are university-affiliated nonprofits, most commonly university teaching hospitals. And then there are other cap-exempt employers like nonprofit research or government institutions. And so those jobs are great to get because again, there's no limit on the number that can be granted each year. And then there are another list of sort of exempt individuals that are up here, and I won't necessarily go through those, but I'll just go through the timeline here briefly of what the H-1B lottery looks like. So in general, if you're going through, meaning if you're going to be sponsored by a private employer, registration for the lottery generally takes place in March of each year. And registration basically just gets basic information about the employer, the beneficiary, and the position. And the registration, unfortunately, just to give you an idea of what the odds are of getting something, getting an H-1B number, if you go through this process, last year there was probably approximately 500,000 registrations. That gives you an idea of what the odds of selection are. Selections happen by the end of March. And then if you are selected, you get between April 1st and June 30th to actually have an employer submit an H-1B petition for you. And so the H-1B petition is where you're demonstrating the merits of the filing. That's where you're demonstrating that you're going to work in a specialty occupation, that you have a specialized degree, and the employer is going to pay you that requisite wage. And if that H-1B petition is then approved, it's for a job that starts the following October. So H-1B positions for cap subject employers always start at the beginning of the next fiscal year. Now I'll just give you my sort of things to keep in mind when you're going through the lottery process, sort of questions that come up quite often, which is, I sometimes hear from individuals who say, like a lot of you probably, oh, I have OPT, and then I also have STEM OPT. So I essentially have 3 years to get a lottery number, and that gives me a lot of opportunity. But if you have an employer who's willing to sponsor you, I would say you should probably ask them to sponsor you in each year. And the reason for that is what we just talked about. The odds of selection are pretty low. So I unfortunately have a number of people who have counseled over the years who have employers who've entered them every year, 3 years in a row in the H-1B lottery, and they've not secured a number. So it's important to keep that in mind, that if you have an opportunity, that you get sponsorship as many times as you can. The other thing to keep in mind is when you get a job, not all employers are going to sponsor you for some of the reasons that we talked about. They're responsible for the majority, if not all, of the costs associated with the H-1B process. So you want to have that conversation at the outset with employers if you can. And you might also want to choose jobs based on who's willing to sponsor you. The other thing to keep in mind is that getting an H-1B number is going to be perhaps more important for some of you than others. And that's because there are long waiting lines to permanent residence people. And in particular, those are for individuals from India or China. And in order to be in the US, until you're actually able to get permanent residence, you have to have another non-immigrant status in the interim. So it's going to be important to get some sort of status, whether it's H-1B or one of the other things we talk about, until you can get a green card that's actually available to you. Just one second. So I did obviously want to talk about these things briefly, just because I'm sure they're at the forefront of a lot of your minds. Obviously, there are two things that came out recently that potentially impact the H-1B process. The first is, of course, the H-1B proclamation, and the second is the weighted selection process, or the rule that was just recently introduced. So the H-1B proclamation, just to try and give you sort of a brief summary, is on September 19th, I believe it was, the president came out with a proclamation that said anyone who's in H-1B status and who's outside of the US needs to pay $100,000 before they can re-enter the United States. Now, of course, that put a lot of people who are outside of the US in a tizzy, and I should say, if they entered after September 21st. And so, of course, there was a large flurry in the community. And then over that weekend, each government agency that has a hand in immigration, so USCIS, US Department of State, and US CBP, who you see at the airport that lets you in and out, came out with sort of updates to that proclamation that said, no, 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 the president isn't restricting admission to the United States. That particular fee applies to new H-1B petitions. Now that creates a lot of questions. And so I will say the initial proclamation by the president, what the president does have the power to do is to restrict admission to the United States of foreign nationals. So arguably that particular part of it isn't necessarily unlawful. So think back to the prior administration when there was sort of the quote unquote Muslim travel bans. Those upheld, at least in some form, those were upheld even by the Supreme Court. So that particular part of it isn't necessarily unlawful. But the fee is probably unlawful. With that being said, there's a lot of open questions that still surround that. So number one is, in light of that new guidance, what constitutes a new H-1B petition? Does that mean if you're already in H-1B status, but a new employer files a petition for you, that that particular petition is going to be considered new and subject to a fee? Or let's just say you're changing work sites. Is that a new H-1B petition? We don't know the answer to that, unfortunately. So there's open questions as to even what the interpretation of that means. And then I will say there's still a view in the legal community, myself included, and most practitioners, that the fee itself is unlawful. And that's because generally to institute a new fee, an agency has to go through particular processes. And then second, fees are supposed to be reasonable and representative of what it costs an agency to process a petition. So it's a pretty difficult to say that $100,000 is reasonable or what it costs the agency to process H-1B petitions. So we are hopeful that there will be litigation that will happen hopefully soon to strike down that fee in its entirety. Unfortunately, I can say with complete honesty that they have had difficulty finding plaintiffs. A lot of companies are in fact scared to challenge the administration, but we are still hopeful that will happen soon, and so that that fee will in fact hopefully go away in its entirety. So again, I wish I had answers for you on that, but right now it's a bit of a we're all just in a sort of a holding pattern. It's uncertain how that's going to apply in the future or if it's going to apply. So the second development that happened very recently, last week, I believe, is that a notice of proposed rulemaking was instituted. And so that new proposed rule happened, and now we have until October 24th in order to make comments on that rule. And then there's an opportunity for those comments to be reviewed before the actual rule would be published in the Federal Register. The timeline of all of that is still a bit uncertain, but just to give you an idea of what that particular rule says, is it effectively prioritizes jobs with the highest salary. And it says that they will receive more chances of selection in the lottery process. So H-1B jobs, we touched on earlier about how you're required to be paid a certain wage. So H-1B jobs always have a wage associated with them of level 1 to level 4, with 4 being the highest. And what the new rule says effectively is that those particular jobs that have a level 4 wage would be entered 4 times in the lottery, and those particular jobs that have a level 3 wage 3 times, etc. So that those particular jobs would effectively have a greater chance of being selected in the lottery process. So it's unclear exactly when that rule will become finalized or if it will, but stay tuned on that. So those are the most recent developments. And with that, I'm going to touch on some of these other options before moving along. And I'll touch on these briefly because, again, I want to leave quite a bit of time for questions. And my voice does appear to be going. So some of the other non-immigrant options that might be available to you guys, and one of my favorites I'll start with, is the L1 intercompany transferee option. So what does this mean exactly? So L1 classification is for individuals who work for a foreign company abroad for at least 1 year and who work in what's called a managerial, executive, or what we call a specialized knowledge position. And then they're being transferred to a related company in the United States to also work in one of those capacities. Now, the two companies, the one you work for abroad and the one you work for in the US, have to be related. So they either have to be affiliates or they have to be parent subsidiary or vice versa. And what I will say is, even though this seems like, oh, I haven't, how am I ever going to work in this particular capacity abroad? How does that work exactly? I can say that a lot of big companies actually utilize this in a pretty interesting manner. as sort of a workaround for individuals who don't get selected in the H-1B lottery. So a large company might say, oh, you didn't get selected this year. So we're going to send you to France to work for our affiliate there for a year. And then we're going to transfer you back to the United States to work for in one of these capacities for our related US company. So there are ways to make this work for you. And some of you might actually encounter this. And similarly, some of you who maybe are in a master's program, for example, some of you might still be able to make use of this if, say, your program isn't that long, because the 1 year period just has to be 1 year within the last 3 years. It doesn't have to be like last year. So it could be that you worked in one of those capacities for a foreign company. Now you've done your master's program for a year, and now that company wants you to start working for them in the US. So there are sort of strategic ways to make this category work for you. I'll touch really very briefly on the E3, which is essentially what I'll say about it is E3 is, yes, it's for Australian nationals. E3 is basically the same as H-1B, but you hold an Australian passport. So essentially, do you still have to be coming to work in a specialty occupation? You have to have a specialized degree, and an employer has to agree to pay you a certain wage. But it is very, there is actually a cap on the number that's being granted each year, similar to H-1B, but there are, in fact, I don't think it's ever been reached. So if you have an Australian background, Australian passport rather, this might be an option for you. The other benefit I'll throw out there of it is that unlike H-1B, it's not capped at 6 years. You can have, it's granted in 2-year increments, and it can essentially be extended indefinitely. So good category to be in if that's an option. The other one that is limited by where you hold a passport from is the TN classification. And the TN classification is for professionals. So professional generally is similar to H-1B, meaning it's generally occupations that require a bachelor's degree or higher. But it's a specific list of occupations that is published, and it says NAFTA here, but and if you Google NAFTA, you could still find it. I think it's USMC now, but it's based on our treaties of trade with those particular countries, rather. And if your particular profession is listed on that list, on that published list, and you have that particular degree, you can potentially attain TN classification. And TN classification is really good. Again, it's granted in 3-year intervals, similar to H-1B, but technically there's no cap on the number of renewals that you could get. So some of the occupations that I would say are most widely utilized that we see a lot are like accountant, architect, things like that of that nature. But if you're from one of those countries or at least hold a passport from there, good thing to look up. And then O1 is for individuals of extraordinary ability. What does that mean exactly? It means individuals who have what's called sustained national or international acclaim in their field. So it might not necessarily be something that's available to you right out of the box outside of graduation, but it might be something that you can utilize down the line. And how do you show that you have sustained national or international acclaim in your field? Well, there's a list of criteria that's published by the Immigration Service that you could take a look at. They're very sort of academically oriented for the most part, I would say. It's, for example, things like, have you made original contributions to your field? Have you published in scholarly journals? Have you served as a judge of others in your field? Etc. And you have to meet at least 3 of those criteria to be considered in this category. So good thing, but might not be available just yet. And then just very briefly, E1 and E2 categories are also similar to, it's similar to the TN classification in E3 in that they're limited by where you are from, but the countries are much broader. So there's a list that's published by the Department of State that you can look at. And it's based on, again, the treaties that we have with those countries. And you can only apply if the treaty exists with that particular country. So the E1 category is for an individual who's coming to the United States who establishes a company that engages in substantial trade with their home country. And E2 is a classification for an individual who establishes a company and makes a substantial investment in that company. And substantial investment isn't necessarily defined, but I would see most of us think of it as at least $100,000. And then the sort of the caveat of both of those is that you could also be an employee working for an E1 or an E2 company in an executive, supervisory, or special skill capacity. So what that means essentially is if that particular company, let's say your parent had a friend who established a company in the US and invested a substantial amount of capital in it, and they still own at least 50% of it, they could potentially sponsor you in one of these classifications as an employee without you actually starting a company. So I'm going to go on and talk briefly about permanent residence pathways. And I'll try and limit this since we're sort of running out of time. And I am running out of voice here. But when we think about permanent residence pathways, what we generally think about is sponsorship. So for pretty much every for pretty much every permanent residence pathway, you have to have sponsorship. And usually that sponsorship comes in the form of a family member or an employer. And there are a couple of exceptions to that, and I'll highlight those along the way. And just because those are probably the ones that you want to most take note of. The most obvious one that comes to mind and that you might have seen, excuse me, in the news is the diversity lottery. And the diversity lottery is, as the name implies, it's a program that was developed for immigration for individuals from countries that have historically low rates of immigration to the United States. So obviously countries like India, China, South Africa, et cetera, are never on the list. And when I say never, it's because the list changes each year. One is published and it tells you what countries are on there. And so if your country is on the list and you meet these very base level requirements, either high school education or 2 years of work experience in the last 5 years, and you're from one of those countries, you can potentially enter yourself into the diversity lottery. And you should. People do win it. I know I've known people who've won more than once. So it is, if it's an option that's available to you, it's a good thing to do. The other thing I would say is if you have a spouse, you can essentially, let's say your spouse is from one of those countries and enters, you can both get permanent residence on the basis of that. So it doesn't necessarily have to be you if you have a significant other that's from one of those countries. So again, the two boxes that we normally think of when we think of permanent residence are family-based green card options and employment-based green card options. Now, there's essentially 6 categories of family-based green card sponsorship. The best category to be in is what we call an immediate relative. So that's spouses, unmarried children under 21, and parents of US citizens. And the reason for that is that there's no limit on the number of those green cards that can be granted each year. And so when we think about permanent residence, I say limit because most categories have a certain number of green cards that are available to them each year. And so that's for family and employment-based categories. There's a cap on the number of green cards that can be issued each year. And because most of those caps are exceeded every year, they're oversubscribed, meaning more people apply than there are slots available. That means that waiting lines have developed in most family-based, except for immediate relative, and most employment-based categories. And so the way that you check what the waiting lines are, whether it's family-based or employment-based, is you look at something, and we check this very often. And if you want to get permanent residence here, you want to familiarize yourself with this. There's a thing called the Visa Bulletin that's published by the Department of State every month. And it tells you sort of what the waiting line is in each of these categories. And again, it applies to family-based and employment-based. So just to give you an idea, so I've put the visa bulletin up here for October of this year. And just to give you an idea of what the waiting line might be in each of these categories, again, but for immediate relative. So let's look back. So F4 is brothers and sisters of US citizens. What this is showing you is that if you were, let's say, from the Philippines and your brother or sister sponsored you for permanent residence, you would just now be eligible to apply for permanent residence in that category if your brother or sister had sponsored you prior to January 1st of 2008. So again, these are sort of representative of what the waiting lines are in family-based categories. And I'll show you the employment-based one in a second, but it's important to understand how this works because if you have a long waiting line to a green card, you're going to need something else to keep you here. As I said earlier, maybe H-1B, maybe A01, but it's something that's important to familiarize yourself with. So when we think of employment-based green card sponsorship, there's technically 5 employment-based categories, and there are actually subcategories within each of these. The 2 most common, and the 2 that a lot of you might ultimately end up getting permanent residence in, are EB2 and EB3. So EB3 includes skilled workers and unskilled workers, but it also includes professionals with a bachelor's degree. And then EB2 is for professionals with advanced degrees. And for the normal employment-based green card sponsorship process, this is what I referenced earlier. The normal process is that an employer has to A, sponsor you, and B, has to test the labor market and prove that there aren't any US workers available for the position before they can sponsor you. And that's what sort of you'll hear people reference when they say the perm-based green card process. So again, that generally applies to EB2 and EB3 filings. And again, what that requires is a test of the labor market. And that test is done through the Department of Labor before the employer even moves on to sponsor you on what's called an I-140 petition with the Immigration Service. And then before you move on to either apply for a green card through adjustment of status if you're in the US or through consular process if you're overseas. And again, that's the normal green card process. But I'm going to highlight just briefly a couple of the sort of exceptions to that rule that you have to have an employer sponsor you and that you have to go through this test of the labor market process. So these are the categories where no perm or test of the labor market is required. And the 2 top ones, EB1 priority workers and EB2 national interest workers, also do not require an employer to sponsor you. So I'll say that again. For those 2 categories, you don't need an employer to sponsor you, and you also do not have to go through a test of the labor market. So what are those 2 categories? So EB1A is for individuals of extraordinary ability. So you'll remember earlier I used that same phrase when I was talking about the O1 classification. So again, the standard is pretty much the same. It's for individuals of sustained national or international acclaim in their field. And again, for EB1A, to be applicable, there's again a sort of list of largely academically oriented criteria, and you do have to meet at least 3 of those to even be considered an individual of extraordinary ability. And then the other one that again does not require an employer to sponsor you and does not require a test of the labor market is in the EB2 category. So what we talked about earlier here on this slide, meaning it's for advanced degree holders. But if you are someone who is also doing work that is in the national interest, so not necessarily always, but a good example is obviously if you're doing research work that has applications beyond just what you're doing, but in the field more generally and for the US, you could be considered under this classification. Now, I highlighted here 2 additional categories that do require an employer to sponsor you, but don't require that test of the labor market. And that is EB1B for outstanding professors or researchers, and EB1C for multinational executives and managers. So EB1C is for outstanding professors or researchers. So what does that mean? To be an outstanding professor, you do have to have a tenure track position at a college or university. If you are a researcher, you have to have an offer of full-time employment at a distinguished company. And similar to EB1A and O1, there's a list of criteria that you have to meet in order to get EB1B classification, but you don't have to meet as many. You can meet 2 instead of the 3 that we talked about earlier. Now, EB1C classification is very similar to what we talked about in the L1A context. So it's for intercompany transferees. So same thing as in the L1 context. You have to have worked abroad for at least 1 year for a company, in this case, an executive or a managerial capacity. And you have to be transferred to the United States to a related company in order to also work in that capacity. So this is sort of the immigrant counterpart, the permanent residence counterpart to the non-immigrant L1A classification that we talked about earlier. So again, these 2 still require an employer to sponsor you, but they don't require a test of the labor market. So that's why we've highlighted them here. And then I'm just going to go on briefly and talk about one additional category that also does not require a test of the labor market and does not require an employer to sponsor you. And this is the EB5 investor category. Now, this is a category that is somewhat similar to the E2 one that we touched on earlier, that's a non-immigrant or a temporary classification. But this is for permanent residents. And it is for, contrary to the E2 classification, where you had to invest a substantial amount of money. In the EB5 context, there are set investment thresholds. And those investment thresholds are currently set at $1,050,000 if you invest in an entity that is in a normal area, I guess I'll say it like that to begin with. And then that investment amount is reduced to $800,000 if you're investing in a company that's in a rural or a high unemployment area. And the premise of this category is job creation. So the idea is that you invest this amount of capital and that you create at least 10 jobs for US workers. And if you do that, you initially get permanent residence for 2 years. And then if you show the Immigration Service that you have indeed sustained your investment and you've created the requisite number of jobs, you can get legal permanent residence in the United States. And there's effectively 2 ways to do this. One is to be an entrepreneur, of course, and to create your own company. But then there are entities that are designated by the Immigration Service called regional centers. And effectively what they do is they sort of function as investment banks, and they offer pooled investment opportunities to EB5 investors. And it is obviously not a category that's necessarily available to all of you. But again, it is one that I like to highlight because, again, it doesn't require an employer to sponsor you. And there is no test of the labor market. So it is one of those sort of outliers in terms of a pathway to permanent residence. So with that, I'm going to wrap things up just so that we have some time for questions. And I'm going to open up the floor. And I guess I will say, I did want to put up here that like we talked about in the family-based context, there are waiting lines in many of these categories, same way that there are in the family-based categories. So again, whether you're getting permanent residence through family sponsorship or employment-based sponsorship, you will have to familiarize yourself with this visa bulletin. So I'm going to stop